tribunal appointed expert, or if you have a tribunal which can really carry out DNA analysis, which is a rarity. In fact, there is one gentleman in our Keating Chambers, London, who does some delay analysis, though he is a barrister. Otherwise, barristers cannot do delay analysis. This is not our area of expertise. We can't. We understand the theory behind this, but it comes when, as Dr. Singhvi said, common sense. Even in delay analysis, all protocol, all literature, all document says that common sense has to be there, experience has to be there, otherwise no delay analysis method you apply, it cannot be perfect. I have taken a lot of time. Now, Mohit, it's for Mohit. Thank you very much. Thank you very much.
Thank you, Mr. Singh. I understand we are all eager to hear Mr. Julian Bailey, but allow me a minute to briefly introduce him. Mr. Julian Bailey is a partner in the Global Disputes Practice team at Jones Day. Mr. Bailey advises clients on international construction and infrastructure projects across a variety of industries, including transportation. Thank you, sir. He's played a lead role as counsel to clients in disputes on most continents, representing sovereign governments, developers, and contracts in complex large-scale matters. Mr. Bailey is a former chairman of the Society of Construction Law in the UK, the leading industry body for construction law, and he is the author of a 3-volume treatise on construction law as it applies in England, Australia, Hong Kong, Singapore, with an international outlook. He is also one of the 9 solicitors in England ranked in Who's Who Legal, Thought Leaders Global Elite 2023 Guide for Construction. Thank you, Mr. Bailey, for joining us. Please join.
Right. Thank you very much. Thanks for the very warm welcome. It's wonderful to be here in Delhi. This is my second visit, and we've heard some very thoughtful speeches and very positive speeches from Chief Justice Ramana and Dr. Singhvi, of course. I just want to start by, first of all, going to my slides to make sure it all works. It does. I want to start by taking up a comment that was made by Mr. Saraf during his very warm welcome. And of course, he was speaking about India and all the positive things that are happening in India and the importance of infrastructure in relation to the further development of India, because it is so important. Every economy, if it wants to develop further and further, needs infrastructure spending. It's very valuable not only to those who do it, but the knock-on economic effects are huge. So this is something that's very worthwhile for any country, and it's so pleasing to see that India is making such a solid investment for the future in its infrastructure. And of course, we were reading today about other things that are happening in India, such as investment in airplanes. I think the largest, or one of the largest orders ever placed for Boeings and other aircraft has been made today. That's amazing. So things are looking up for India, and I wish India all the very best, save in one respect. And I'm pleased to say I'm joined here by a fellow Australian, Professor Jones, because I'll probably need some moral support for what I'm about to say. As some of you will be aware, there are some other Australians in Delhi, or who will soon be in Delhi, who haven't had much success here so far in the cricket, and we can only hope for them great success in what's to come. Now, to go to something far less interesting than cricket, which is delay in construction. When we think of construction projects, we shouldn't always think of them being delayed and disrupted. If we have an illustration from this particular slide, which tells a certain story, perhaps an alarming story in a way, the headline is Chinese construction firm erects 57-story skyscraper in 19 days. And if you click on the thing there, you can see it being built. Now that must be a record of sorts. You might wonder what the quality of the building was like once it was finished, but in terms of getting to the top, that's quite an achievement. But that's not always how things go, of course, because at the other end of the spectrum, things can move at a more glacial pace. Some of you will know this particular building. It's a church in Barcelona, the Church of the Holy Family. They broke ground in 1882, we're told, and practical completion for this particular church is due. The latest forecast is 2026, but don't hold your breath about that. So there's an illustration of how things can take a more leisurely pace when it comes to construction. What's the general picture, though? We can take these two extremes. I've got an illustration here which comes from an architect from a UK publication which was published a few years ago. You can see the headline: almost 2/3 of projects were late in the past 12 months. And the text beneath that says, a staggering 60% of projects were delivered late to clients over the past year, according to new data. Now, maybe that's not the most precise survey, but it could also be emblematic, and maybe it resonates here in India, I don't know, when it comes to the time in which we finish late. That's true, and maybe that's unavoidable. We don't really know, but what we can do is identify some of the causes of projects being delayed. I want to keep us in the UK just for a moment, if you'll bear with me. So RIBA is the Royal Institute of British Architects. They do a survey every couple of years. They go out and ask people in industry a number of questions about what's going on. And one of the questions that they ask, which I've got here at the top, maybe you can read it if you have good eyesight, says, so the question at the top is from this 2022 report: during the construction phase of the project, which, if any, of the following matters impeded project progress during the past 12 months? And this will really test your eyesight. On the left, they list out a number of potential causes of delay and ask people to respond and say, well, which ones have caused delay to you? I just want to focus on the top four. Number one is at 60%, is employer's variation. So this is where the employer has instructed the contractor to do something differently, and that has caused delay. That's the number one cause of delay. Number two is a recent comer to this particular survey for reasons which will become apparent: safe working practices, including restricted access to site. That was the number two cause of delay. And that's more of a neutral cause, not the responsibility of the employer or the contractor. COVID came out of nowhere. It wasn't really anyone's fault. Whereas the first one, the employer's variation, is something the employer is responsible for. Go to number three, which is required construction products not being available. So supply chain issues. I think we're more than familiar with those particular issues. Construction firms have had great difficulty in the last few years in getting products on time from their main sources, including, of course, China, where we've seen obviously lots of pictures of ships being stuck in the shipyard, not going anywhere. So that's been a cause. That, again, is more of a neutral matter, but as a matter of risk allocation, the contractor usually takes the risk of such problems with its supply chain. And number four, and so the last one I would look at, is slow pace of construction. The contractor is running late. This is purely a matter for the contractor's responsibility. Now, the reason I want to draw attention to those four causes of delay is essentially to draw out something about them, which is they don't have that much in common. Yes, they all cause delay, but in terms of legal and contractual responsibility, it varies. Number one is an employer risk, the variation. 2 and 3, COVID and supply chain problems, could be employer, could be contractor risks. Number 4, slow pace of construction, is a contractor risk. So what that tells us, I think, is that if we're looking at a project that has been delayed, and we ask the question, why has this project been delayed? What are the causes of that? Chances are the answer we might get is through a multitude of causes, some of which are the responsibility of one party, some of which are the responsibility of the other. And what this almost inevitably means is that when the matter goes to dispute, whether in arbitration or court, there's a fight between the parties as to which particular delay was the real cause of delay to the project. Now, to bring out these issues a bit more, looking at the conflicting cause of delay, and to try to bring this to life a bit, we've come up with a little factual scenario that will hopefully stimulate some thoughts about these issues, because it's better to discuss things with a factual context as opposed to in the abstract. So, what have we cooked up? Imagine you have a project in a country called Xanadu, the Kingdom of Xanadu, and the project is for the construction of a motorway segment. It's 25 kilometres long. It has to go through part of a mountain, so there needs to be a tunnel segment, and that tunnel is going to be 2 kilometres long. That's the overall project. From a contractual point of view, this contract uses a FIDIC form of contract. Some of you here will be familiar with this brand of contract. It's used widely internationally for projects in Asia, in Africa, Middle East, many parts of the world. It's probably the leading suite of international contracts. The particular form we've chosen is from the 1999 suite. This is this particular contract is the MDB Harmonised Edition. It's a form of contract used for international aid projects in particular. It's approved of by the World Bank. So it is called the Pink Book for short because of the colour which you can see in that strip. So the Pink Book has been used here. Now, what else do we need to know about this particular contract in this factual scenario? Well, let's assume that the contract was entered into on the 1st of November 2019, which is important for reasons you'll soon see. The contract subject to English law. The time for completion is 24 months, so the works have to be complete by the 1st of November 2021. Contract price is $100 million, US dollars, and as typical for this form of contract, or this type of contract, there are liquidated damages for the contractor being in delay. And the LDs are to apply at a rate of $100,000 a day, up to a cap of 10% of the contract price, so $10 million. Right, so that's the contractual setting for this. What happens? Well, the contract's signed, and then the contractor sets to work. And the first bit of work that it starts on is the tunnel, the 2-kilometre tunnel, which it starts to work on using rock blasting methods. So that all sounds good, but there's a problem. In February 2020, so a few weeks after the contract's signed, people realise a mistake has been made. Why? Because the contractor started to construct the tunnel in the wrong spot. Not too far away from the right spot, but just the wrong spot. So it's been blasting away in the wrong area, and once people realised the mistake, they then corrected the course of the tunnelling works. But this was going to cause delay because they had to start the tunnel in the right spot much later than they anticipated. Now the contractor thinks it's going to be delayed by about 2 months because of these tunnelling works being relocated. So that's the first problem. But then it actually gets worse for the contractor because we move into March 2020 now, and our dear friend or enemy, COVID, appears. And it appears in Xanadu as it appeared in many other parts of the world in around that time. Now, the government of Xanadu responds in a way which is familiar to us. Oops, we've lost the slide. There might be a small delay in my presentation. Wish I claim a 10-second extension of time. So the government of Xanadu passes laws relating to code, and these laws have the effect of requiring people to engage in social distancing, both in workplaces and elsewhere. It restricts the travel of people, and it also restricts the movement of goods. So it's going to have an impact on this project. Moreover, the government of Xanadu orders that construction sites be shut for a period until the COVID situation is brought under control. But then in early May 2020, the government of Xanadu says, okay, you can reopen your construction site, but you have to engage in social distancing, etc. So this is going to have an impact too on the contractor's works. And the contractor estimates that it will be delayed by about 3 months in completing all of its works. And of course, this delay affects the entire project. So all 25 kilometres of the project will be affected by the COVID issue. Now, what does the contractor do? It claims an extension of time for completion of the works, a 3-month extension of time. That's its estimate for the impact of COVID, which may or may not be fair enough. However, the engineer at the time rejects the claim and says, no, you're not entitled to an extension of time. You're in delay because you messed up the tunnelling works, so I'm not going to grant you an EOT. So that's not particularly good for the contractor. So what happens next? Well, the project goes forward, it proceeds to completion, and it completes on the 1st of January 2022, which is 2 months late. You remember the completion date was 1 November 2021, so the contractors run 2 months late if the contract date for completion is unadjusted. The employer's position is very simple. It says, well, you, the contractor, have overshot the completion date by 2 months. I am entitled to claim liquidated damages from you for a period of 61 days at $100,000 a day. That's $6.1 million that you owe me as liquidated damages. The contractor, for its part, disputes this and says, no, that's not right. I was delayed primarily by COVID, and I claimed an EOT, and the EOT was wrongfully rejected by you. So you're not entitled to claim liquidated damages from me. So the question then becomes, well, how is this to be addressed? And in order to answer that question, we need to look at the provisions of the contract. We need to understand the legal analysis of the relevant parts of the contract. The first question becomes, who takes the risk of delay in relation to these particular matters? And the answer that English law takes to these issues generally, there's no common law on this, other than this cardinal principle, which is that of freedom of contract, something that our friend George Michael was singing about for ages, or so I believe. This is the idea that if competent people sign a contract and they've open eyes, they will be bound by those terms, and the court will or an arbitral tribunal will apply those terms and not seek to get around them somehow, even in the case of standard forms of contract. That's the idea. We've got to look at the contract and what it says, which means we need to look at the relevant provisions of the contract concerning extensions of time. In this FIDIC form, I've got some text there from subclause 8.4, which we can look at in short order. It starts by saying that the contractor shall be entitled, subject to giving notice, to an extension of the time for completion, if and to the extent that completion is or will be delayed by any of the following causes. So the contractor shall be entitled to an EOT if it's delayed by any one of the following causes. And then we have a little shopping list of things that may entitle the contractor to claim an extension of time. And this is a fairly typical sort of a list for a contract of this nature. Subclause A is a variation. So the employer instructs something different. And if that causes delay, the contractor can claim an extension of time. B is essentially a cross-reference to other provisions of the contract. C is exceptionally adverse climatic conditions, which is an open textured sort of a context. It rained a lot, the works couldn't proceed. Is that exceptionally climatic conditions? Well, if you're building in a desert environment, it probably is, but not if you're in the tropics. So that's quite an interesting idea there. But let's get to the most relevant one for our purposes, which is D. And this refers to unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. That's quite relevant in relation to the contractor's claim for an EOT due to COVID. Why? Well, because personnel weren't available, they couldn't go to work, they couldn't go to the construction site was closed for a period of time. And there was a knock-on effect in relation to goods being available. What was the cause of this? Epidemic, COVID itself, and also governmental actions. The government of Xanadu passed laws requiring sites to be shut and imposing social distancing restrictions on the contractor. So that's the basics. Those are the basics of the contractor's EOT entitlement. So it is to claim an extension of time if one of these events occurs. And this has happened here. What then happens? How is the EOT to be dealt with? Well, again, we have to look at what the contract says about this. And in the FIDIC form, it's actually quite vague. And again, this is not atypical by any means in relation to construction and engineering contracts. So the first part of this particular clause, which is subclause 3.5, it puts the engineer, so the person administering in the contract, in the position where he or she has to address the EOT claim. First of all, by either trying to get the parties to agree on the EOT, well, that rarely happens in my experience. And then we have the second sentence, which is key. If agreement is not achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. So that is all the contract has to say about how the EOT claim by the contractor is to be addressed. This very vague language talking about a fair determination, taking into account all relevant circumstances. So what does this mean in practice? Well, starting from what the engineer needs to do, the engineer needs to make a fair determination. So what is a fair determination? Looking at how the engineer should approach the matter of the contractor's EOT claim, a fair determination at the very least means doing one's best on what is being presented to the engineer and acting in good faith. So what might this mean? Well, if an EOT claim has been presented by a contractor, it doesn't contain a lot of information, but the engineer can see that there is a genuine EOT entitlement here. What might the engineer do? The engineer might say, please can I be provided with more information on this, that and the other to allow me to make my fair determination. What the engineer shouldn't do in that situation, at least, is simply reject the claim, to say, well, you haven't given me enough information, so you don't get an extension of time. So what this clause requires an engineer to do is to really to seek out, if the information isn't provided, some information about the EOT claim, and to really to act in a professional way in assessing the claim. I just want to now move on to something which might seem slightly perplexing from the slide that's just been presented here. And this is a comment on this type of language that we find in relation to extensions of time in construction and engineering contracts. We've had this very vague wording saying the contractor is entitled to a fair and reasonable EOT. Very, very general, not precise at all. This wording's been around for a long time, since the 19th century at least. And you might ask, well, why do contracts use this wording? Even now, where perhaps we can be more precise. And to give my answer to this question, I want to come back to what we see down the bottom of the slide here. And can I just ask a question? Does anyone recognize the gentleman on the slide? Yeah, not Kalashnikov, yes, Lieutenant General Mikhail Kalashnikov, who is holding a version of the gun he invented. So that is a Kalashnikov, and that is Lieutenant General Kalashnikov. Now, you might think, why have I got a picture of him there on this slide, and why is there a target there? I think the story of the Kalashnikov is relevant and instructive to what we're looking at, and please bear with me on this. The Kalashnikov was developed just after the Second World War, which, of course, the Soviet army was successful on the Eastern Front against the Germans. But one thing they noticed while they were fighting the Germans was the Germans had better guns than them. So when they were doing when they were taking stock after the end of the war and looking at what they can do to improve things, they held a competition in the Soviet army to come up with a type of gun that their soldiers could use. And as we know, the Kalashnikov won the competition. Now, what I think is interesting about this gun design competition is this. The Kalashnikov was not and is not the most accurate of guns. If you shoot at the target, it might hit the bullseye a couple of times, but then it will sort of spray around the target. Whereas the other prototypes for this gun competition were much more precise. They could hit the bullseye again and again and again. So you might ask the question, well, why on earth did the Soviet army people decide to go for this less accurate gun over one that's going to hit the bullseye? It Don't their soldiers want to hit the enemy in the right spot every time? And here's the answer, which we know about. The Kalashnikov is a simple gun, simple to assemble, simple to use, and it's very versatile. And it can be used in all sorts of situations. It could be raining, it could be snowing, it could be very hot, it could be dusty, etc., etc. The gun will fire. It's not going to seize up and be unusable. So that is why it is so useful. It hits the target each time. These other prototypes, by contrast, they weren't reliable in these particular circumstances. They might be okay in the firing range, but once they get out into a dusty place or a hot place or whatever, they would seize up and therefore be useless to the soldier carrying the gun. So, bring it back to FIDIC contracts and extension of time clauses worded in this very vague language, saying that a contractor is entitled to a fair and reasonable extension of time. Why do contracts do that? I think the reason is this. What is being contemplated here is someone like an engineer, a contract administrator, working on a live project, dealing with lots of data, dealing with a project where the work is being built. The person doesn't have much time to engage in detail with all the various things, payment valuations, extensions of time, etc., etc. So what the contract calls for is for the engineer, in this case, to do his or her best based on the information available. So the assessment of the EOT doesn't have to be precise. It just has to hit the target in some way where the contractor is clearly entitled to some form of EOT. So that's the thing to understand about these clauses. They don't call for a precise answer. There can be more than one answer when it comes to understanding what a fair and reasonable EOT is. And that approach actually chimes in a way with how delay cases were dealt with historically, going back maybe a century, maybe even less than that. I've got an illustration here on this slide from what I've described as the good old days. This is a case about a contract to build a ship in England, 𝐂𝐨𝒏𝒐𝒕𝒆 and Priestman from 1915. So the contract said the ship had to be built and delivered by 28 Feb 1913. There was an extension of time clause in the contract that allowed the builder to claim an EOT if, among other things, the workers went on strike. So if there's a workers' strike that caused delay, an EOT could be claimed. Now, for this particular project, there was, in fact, a delay caused by workers striking. It was a national strike in England in 1912, and that delayed the work at the shipyard. So the contractor claimed an EOT, it was rejected. The matter went to court. It went before a jury, and the jury was asked the question, what extension of time, if any, is the shipbuilder entitled to? And they came back, and they said 70 days. So that was the answer. No reasoning, they didn't have to give any reasoning. That was it, and that gave the answer to the important question. The thing to understand there is that there was no kind of precision or requirement of precision in the jury coming to that conclusion. Just as with the contract administrator, the engineer, precision is not needed under the terms of the contract. Now the question becomes sharper when we move forward to the software, Primavera, and others that can be used to determine the critical path of a project and the impact of a particular event. So you can come up with a precise answer to one of these questions, but then the issue becomes, do you need to come up with such an answer? Do you need to use this kind of heavy-duty software? Well, always we come back to what the EOT clause in the contract says. Now one of the main issues, coming back to our factual scenario, which I've tried to set up, made for David to have a go at, is where we have periods of delay which overlap with each other. We remember we had the tunnelling works being delayed at around the same time as the COVID issue took effect. And if these risks are subject to different allocations, one is an employer's risk, the other is a contractor's risk. The question is, what does the EOT become when it's assessed under the contract? These two events have an impact at the same time. And in relation to that, I'm going to stop there and hand over to David once he's introduced. Thank you very much.
Thank you, Mr. Bailey, for those inputs and the wonderful presentation. I know delay is the buzzword today, but I'm not going to take more time, but briefly introduce Mr. David Thomas. David Thomas is an illustrious barrister with a sterling practice both in the UK and the overseas. He's a member at Keating Chambers, a leading set of commercial barristers chambers with a thriving domestic and international practice. And he's known for his incisive cross-examination skills, commercial awareness, and the clarity and practicality of his advice. He has been instructed in some of the biggest and highest profile cases in the world, including the Shard, the Wembley Stadium, the Olympic Stadium, and the Burj Khalifa. He advises regularly on new engineering and construction contract disputes and has conducted numerous adjudications and mediations in relation to engineering and construction contracts. In addition to his thriving practice, Mr. Thomas sits as an arbitrator and adjudicator both in the UK and internationally. Thank you for being with us, Mr. Thomas. Please join us for a presentation.
Well, good afternoon, everybody. Thank you very much for inviting me to speak today to such an illustrious and distinguished audience. I'm very grateful to be here. Just picking up on two things that have been said so far by the previous speakers. Julian mentioned cricket. Well, I'm being provoked by an Australian to get into cricket. But as I'm in India, I won't spend the rest of the afternoon talking about England's record run chase last summer of 378 with centuries by Root and Bairstow. No, I really will steer clear of that and go back to construction contracts and delay and how you present a delay case. I think the other remark I just wanted to pick up on was from previous speakers have talked about all of the fantastic infrastructure developments that are taking place and are going to take place in India, and the need for a greater body of construction law expertise in this country to support that. And that's a very laudable aim, and it's a process I think that in my own country we've been through in past decades, and I very much endorse what's been said about that. I think there's another angle to all of that for you, though, and where I have seen your countrymen in recent years is going out into the world. So it's not just in India, but I see Indian contractors, for example, very active in Middle Eastern markets at the moment and getting into disputes there. So I think also you'll have a need, and you'll have business opportunity as lawyers for assisting your clients with challenges and problems that they may have in overseas jurisdictions. And I think, in a sense, that may be the perspective that Julian and I are bringing this afternoon, because that is probably where we actually see Indian clients getting involved in disputes. And so my remarks certainly do come very much more from that perspective. Now, if I can just use the slides to help with some ideas about how you present a delay case, or how you resist a delay case if you're on the employer side of it. Now, how do I make this work? Which is it that one? Yeah. So, I wanted to just address this through some stages of how you're going to present, really, and what you've got to present about. Just a word about pleadings at the beginning, be they traditional common law pleadings, as it were, setting out material facts and just that, without attachment, albeit memorial style, which you'll see in some arbitrations, where you have to attach the documents you rely on and your witness and expert evidence that is going to support your case. But either way, your pleading, your head pleading, your statement of case, and then equally the defence, that's your first piece of advocacy. And it's really important to make the most of it. It's the first thing that the tribunal will read. It's actually what the other side will read. And if you want to get a settlement, the better that document is, then the more chance you actually have of a settlement, and the more chance you have of winning over the hearts and minds of the tribunal. You do need something that is a nice, clear read that just sets out your case theory, so that everyone can go back to it and know what your point is. Now, you do actually see, even today, in whatever jurisdiction, I'm afraid, some really quite poorly pleaded delay cases still. Delay cases can be difficult to plead simply because there's such a sort of miasma material to sift through and get into order. But be you for contractor or employer, it is really worthwhile in investing in this your statement of case or your defence. Money invested in that at the beginning for your clients is probably money saved later, because you've got your case into some sort of order, and you won't be having to change it later, at least not radically, and you will have your guidelines if you're doing your evidence at a later stage. You'll always know, what your theory is. So very well worth doing. For delay, how do you go about pleading a delay case? As I say, it can be difficult. You will have to really work at it. I think what you've got to try and do as a claimant contractor, you want to say what events you are relying on as your delaying events. You need to say which part of the contractual clauses you rely on to say that entitles you to claim extension of time. So which of those subparagraphs in the example Julian showed you rely on. And then you do need to plead in relation to causation. I'll come and talk a bit more about causation, but the outline of what your case is, this is the event, it's under this clause that we can claim. It caused a delay to this activity, and because that activity was delayed, completion was delayed like this. And just get the basic sequence written down. How is it that that event delays a certain activity that then causes a delay to completion? Because as we've seen, it's delay to completion that matters, not just delay to a particular activity. So try and get that into the pleadings to start with. If you're for the employer responding to that, then try and mirror that. I know the contractor will bear the burden of proof, of course, but it's much more convincing for an employer to say, not just denied, 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 but to say, that's not right. I've got my own story here. I had a project manager there. We know what happened. That event didn't cause a delay. Something else did that was your fault. So, and that, of course, is what's beginning to happen in this scenario. The employer said, no, it was your own mistake with the blasting that caused it. And so much better as an employer, once you get into arbitration, to set out a positive case if you can. So now let's look at liability in a bit. Yes, there we are. We'll now look at liability and causation in a bit more detail. So liability, one thing that comes up quite a bit these days in delay cases is clauses like this clause that's in the FIDIC contract. It's notice clauses that, on the face of it, make giving a notice of the delaying event as giving rise to a claim as a condition precedent to being allowed to claim. In other words, you lose your claim if you don't give the notice within a certain time. So this contract has this in it. Claiming party shall give a notice as soon as practical, no later than 28 days after the claiming party became aware or should have become aware of the event or circumstance. If the claiming party fails to give a notice within this period, the claiming party shall not be entitled, and some convoluted long words, but basically shall not be entitled to an extension of time or to financial compensation. So it's a liability step that really you may well have to deal with in contracts of this sort. Bear in mind that the approach to these clauses can vary depending on what legal jurisdiction you are in, which law you are governed by. So if, for example, you are in a Middle Eastern jurisdiction, you're governed by that law, a civil law and Sharia influenced law, then you will find that tribunals are much more likely to avoid this clause for you because they have very strong ideas in those legal systems of good faith, and they'll say it's not right for an employer to be able to rely on this clause if it's caused a delay. Those legal systems have a point. Think about the fairness of something like this, as those legal systems I think do. here we've got COVID, an employer risk. Let's say that was the only cause of delay. Or take something more extreme. It's the employer, let's say, in breach of contract, denied access to the contractor at the beginning of the project, didn't make the land available for 2 months. And that causes a delay to completion, as well it might. But the contractor, thinking that's blindingly obvious, doesn't give a notice. Result, at the end of the project, contractor says, well, I want my 2 months extension of time when it all finishes up 2 months late. Employer says, well, no, you didn't give a notice, you don't get an extension of time. And I'll have 2 months liquidated damages, please. Is that fair? Well, the answers of the civil law systems, which you might be under in the Middle East, is probably, no, it's not fair. And the employer shouldn't be allowed to rely on its own wrong to give itself a right to liquidated damages. So you might, in certain circumstances, get that answer. You might have some sympathy with it. Equally, you might not, and English-type legal-based systems take a different view, and the English courts have said, well, we hear what you say about fairness, but you contracted out of that. You agreed this condition precedent, and we are going to uphold it. That's the basic approach of the English courts and those that follow similar types of reasoning. I think in India you have some conflicting authorities on that, I believe. But so you can meet different approaches, and is what I'm saying to this, and it's quite a common issue these days. Even if you do find yourself in under a system of law that is going to uphold this clause, and you've got a client that didn't give some nice plain notices, headed up notice of delay, notice of claim, something like that, then all is not lost. There are a number of avenues that are open to you. What does the clause really mean is one thing that you would always explore, and how does that apply to the facts of your case? So on this one, claiming the time runs from the claiming party becoming aware or should have become aware of the event or circumstance. So you can explore the facts of that. You might want to say, well, at the time, you can say it with something like access, but for some things, you may be able to say of your contractor client, we didn't know at the time. In fact, we didn't know until our delay expert told us 6 months ago. So that you can explore. Notice usually only means in writing, so you can rely on anything in writing. Might be minutes of meetings, might be emails, doesn't have to be formality usually. You've got to look at the contract quite closely. Probably it's often that. Or you might be able to rely on an estoppel and say, well, it just wasn't the practice to rely on this, to give these notices. Nobody expected it, and we all knew that. So you might have that available. That's an escape route sometime for contractors that haven't followed this. Just a note on tactics. Employers sometimes try to take this sort of issue, you didn't give a notice, you lose, as a preliminary issue. Great thing for an employer to take as a preliminary issue. Not so hot for the other side, I'd suggest. If you're in a situation where your notice case is a bit iffy, you haven't got some nice neat notices, or you're missing some, you want all the facts on the table. You want the sympathy of the tribunal. You want them to believe you've got a good case. You want to build up your credibility. You want the whole story out there so that this is seen as one small piece of the jigsaw and that your basic merits have got across. If you take this as a dry contractual issue, you are much less likely to do well if you are a meritorious claimant, because that won't get seen. So just watch that tactically. So that's a sort of prior issue that is often there these days. But then just a little more on liability. Obviously what you've got to do is you've got to rely on the EAT clause. How do you get under it? Just to note, just bear in mind, these clauses are for the benefit of both parties, for the benefit of the contractor because he can get an extension of time under it. Also a benefit to an employer to have the clause in because it means an extension of time can be given and he can thereby limit the extra time that the contractor gets. If there isn't a clause like that and the employer actually has prevented the original completion date or hindered it, then the completion date goes, and there's no substitute date, and the contractor is generally just left with a reasonable time to complete. So it protects an employer as well and controls and limits his risk. So you've got to establish that the event's within or outside the clause. In the scenario we've got here, that looks relatively simple because we saw the clause was an epidemic or government action making goods and materials and personnel not available. So that seems to have happened. There's another aspect of the clause which I'll come back to, but basically getting the event within the wording doesn't look difficult here. It might be more difficult in some cases. If you're relying on a variation, there might be a big dispute about whether there's really a variation or not. Might be a dispute about whether the weather conditions were really severe enough, about whether there's a breach of contract, about what the contractor's scope really was, disputes about the meaning of the specification and so on as to whether there's a variation or whether there's a breach. You might need, just thinking in terms of presentation and necessary evidence, you might need technical evidence in particular from experts on that, just to establish that you are within the right clause. One word of caution, though, about the liability case in delay cases. One common error, I think, in the presentation of these cases, perhaps picks up on something that Ratan said earlier, is an over-focus on it by claimants. Claimants tend to think, well, I can establish I've got a variation. It was a big variation. It was obviously lots of extra work. It obviously delayed the project. I'm going to have an extension of time. Not so. Yes, you've got to show that, but it's no good focusing just on liability. It doesn't carry the day on its own, and you do have to always establish causation, and that is really where so often in these delays cases there just isn't enough focus and thought and clarity of explanation put into the case. It's absolutely vital that this is focused on, and what you always have to show the causation. The wording of the clause is relevant, and the key thing in almost all of them is, and the one here, and it's picking up Ratan's point earlier, is the relevant delay for an extension of time, which is also going to found your claim to money. The relevant thing is to show a delay to the completion date. It's not just a delay to an activity, it's to the completion date. Right, I'm being asked to wind up in 5 minutes, so I will accelerate, which is another piece of jargon from the construction industry, and try and pick up key points. Big thing, I think, in presentation of your evidence in a delay case is the best way to do it for most tribunals. In my experience, if you really, as a contractor, want to persuade a tribunal, use the factual evidence as your main vehicle. Yes, you will use a delay expert for support, but the most convincing way to do it is if you've got somebody who was on site through the project, or you may have to do it through more than one person, get them to tell the story. And a delay case is a story, and you need to get your story set out, whichever side you're on. I mean, the defense side, the employer, equally has to tell its story as well through its project manager. Tactics, minimum number of witnesses to tell the story, ideally one from whichever side you are. If you can't do it in one because personnel change, well then do it in two. Do not have a proliferation of witnesses dealing with the same events, because they'll end up contradicting each other. However good they may seem, they probably will. Cross-examiners will try and lead them into it. They'll use the documents which will almost always give opportunities for that, and credibility will get damaged. So minimize it. And always present these witness statements chronologically. Always reference them into the documents, reconcile them to the documents. If the documents don't appear to fit, have them explain it. Have them deal with criticality as well, as far as they can. If this is a well-organized big project, your project manager on either side will have an awareness of what's critical. It's going to be a pretty poorly run project if they didn't. So they should be able to explain what they regarded as critical at the time, why they took the steps that they did, and why delay was being caused. Have them do that. Role of experts then, briefly. Yes, you're always going to have a delay expert in a delay case. In my own view, they play a supporting role to the witnesses if you've got the witnesses. If you haven't got witnesses, then they'll have to play a bigger role. That, in a sense, I think says something about you having a weaker case, whichever side you're on. Delay is a question of fact, it's not a question of opinion. What really is the role? What is the expert role here? I think there is a role, a genuine opinion expert piece here, and it's where's the critical path? And I think that's the biggest and most important piece of support you can get from a delay expert for your case. Often, the key dispute is about where is it? The events are known, that they impacted on the next activity is known, not disputed. But was that event critical or wasn't it? And I think experts do help there. That helps in preparation as well. Work with your expert in preparing, get them effectively to audit, support what your own people think, your own witnesses think. Were we right about the critical path? If further analysis by an expert suggests that our people at the time had misjudged it and actually the critical path lay elsewhere, then that's something that you can tackle. All is not lost because there may still be a relevant delay. You might run into notice problems, but again, as I said at the beginning, you might only have just found out. So use experts sensibly like that, but they are not the be-all and end-all, they're really not. And I think certainly in the UK, fashion has moved away from great reliance on them, and there's a little bit of skepticism about all these computer programs. I mean, you get out what you put in, so there's a little bit of a feeling that maybe there's a black box there. So facts, facts, facts is really what it's all about. Quantum evidence is really important. In a delay case, there will be a mass of quantum information to pull together, lots of different headings of quantification of a delay claim. Get an expert to pull it all together. Ideally, get as much of it agreed with the other side as possible, whichever side you're on. It's in everybody's interest to do that. Do it on the basis of really trying to get an agreed menu. So if this on liability, the money's that. If this, it's the other, and so on. And usually you can get, with sensible experts on both sides, you can get a decent measure of agreement, and that really will help the tribunal. It will get you an award more quickly, because if you leave a mass of quantum disputes to a tribunal, that's a nightmare job for the tribunal to sort out. It really is. So try to endear yourself to the tribunal, help them by trying to get quantum in order through your experts and reach an agreement. Now, I better just go on. I'm going to skip over the methodologies that are in the delay and disruption protocol that experts can use. You can look at it in the protocol. Ratan's told us about the protocol. The IBA rules, I don't think I need dwell on them. Very helpful guidance in international arbitration, often referred to these days in the contract. You'll find the arbitration clause may well say that they apply in an arbitration. They kind of blend cultures of common law and civil law, and require essentially good faith behaviour and letting the other side know what your evidence is. So they're very helpful. If they're not adopted in the contract, they're frequently adopted by the parties in the tribunal in terms of reference, if there are any, or in procedural order number 1. So something to be familiar with and really quite helpful. Concurrent delay. Now that's getting back to our scenario now, and what the delay and disruption protocol tells us, and it reflects the approach of legal systems, certainly the common law system in England, and just pick up the last 3 lines there, where contractor delay to completion occurs or has an effect concurrently with employer delay to completion, the contractor's concurrent delay should not reduce any EOT due. So, if that's the orthodox approach, what have we actually got here? Have we got concurrent delay? True concurrent delay is where both of the events, both the employer event and the contractor event delay completion. It's delay to completion, remember. That's the fact that we're really interested in. So here, COVID stops the work. Must be critical. Nobody can do anything. So it's got to be critical. Linear projects have slight peculiarities. Perhaps we'll pass over that as well. It's repetitive work, and you might just have more than one critical path in a linear project like a road. It's a separate topic of its own almost. But now this tunnel, 2 kilometres of tunnel, it might or might not be critical, actually. Depends on the facts. Always, it's the facts. What are the particular facts of the case? It's just 2 kilometres out of 25. All right, you can't do it when you planned it because you made this mistake, and you're going to end up, therefore, doing it later. Does it make any difference? Might not. It's only 2 kilometres out of 25. Who says it's got to be done first or in the middle? Do it later. Might not affect completion. On the other hand, might have a big impact. Suppose you've got to do the tunnel to get to the other side, to build the road the other side. Almost bound to cause delay. So you've got to dig into the facts to see whether it's critical or not. If it is critical, then there is going to be concurrent delay here, and if it's not, not. So there's no simple prescribed or formulaic answer. You've got to actually examine the facts to see what happened. Then, just finally on compensation, basically you're going to get compensation for the extra time. Very important point, though, again picks up on, almost finished, last slide. The point that Ratan was making at the beginning, that the difficulty he had in his case, the compensation for delay, prolongation of a case, the financial compensation is for the delay when the delay happens. Now that's quite important and can make quite a difference. Can actually quite suit a contractor, and it's something to think about tactically if you're acting for a contractor. Good idea to work out where the money went and start to think there and start to think about where you're going to put your efforts to get the best return. Contractors' costs on a project, normally, I mean, everything's different. The orthodox thing is for contractors' costs really to be incurred in a sort of bell curve from the beginning of the project, as sort of mobilisation costs start off fairly light. But then when sort of the work really gets underway, sort of groundworks and foundations, and there's lots of materials being procured and there's more people on site, the costs go up and up and up. And then they're at their highest level in the middle of the works. And then as you get towards the end, they tend to be tailing off again. So it's orthodoxly a bell curve. So the most valuable delays, if you like to see it like that, for a contractor investing in a claim, the most valuable ones are in the middle. So think tactically about the money, which delays or potential delay events that we are going to rely on are going to pay the biggest dividend. So just think a little bit tactically with your experts and your witnesses about how you're going to put your case for your own benefit, as well as putting it fairly and attractively and credibly to persuade the tribunal. That's accelerated a bit. Here's a gentleman that may look familiar to some of you, who some feel has some questions to answer. I think the three of us are happy to answer questions, but for a different reason. Anyway, if questions are appropriate and there's still time for them, I'm sure that we can deal with that. Ratan and Julian will take the difficult ones, and I'll take any others.
Thank you so much, Mr. Thomas, and apologies for rushing you, but thank you for the presentation and inputs. Mr. 𝐂𝐨𝐧𝒏𝒏.
I think I just don't want to stand now. I wanted to speak a little bit about the Indian context of damages, and particularly I think if you see today in India, the biggest contracting party is the government, and they deal with a standard form of contract. And then you have a penta test rule that you can't read implied terms of the contract. And therefore there's a very limited thing you can do. You can follow the notice, and then you get totally hammered by Section 73, what you can ask under the Indian Contract Act. But I think more important than for me to speak, because I really wanted to speak a lot, and it's core to my heart. I started like an infrastructure lawyer years back, but I think I have a very interesting people in the room. I have Hemant Kumar, who is the Larsen and Toubro General Counsel, and he's one of the biggest contracting company in India. And I have Rabi Sabharwal, who is the General Counsel for JSW, a biggest employer in India. And we have a pretty interesting thing. So I think what we can do is just have a few minutes of discussion, and I think I will just get a mic to you and understand really the perspective. Really what is important is, because we all work under these basic thing is that the principles, the governing principles which are globally done and quantification, but when eventually it gets into 73 and it gets into notices, it gets procedural, and then you have to show that you actually incur damages. Like you heard about all the cause factor. But remember, like in every contract, earthquake will be an important factor. But then you say earthquake came and went off in 2 minutes, but the impact can be very big. And that's the reason why I differ with Dr. Singhvi, that particularly on the delay analysis, if you do not have expert, you'll make a mess of it, because this is really not a lawyer's argument. This is really what you have to understand is what really happened and how critical it was. I think David also mentioned that it's very important to understand how critical that issue was and what did it delay and how much did it delay. I think, Hemant, why don't you start and we get a mic to Ravi. Anybody else want to speak? But I just we want to have a discussion and make it a little bit more interesting.
We have spoken much about coronavirus. That has indeed created more than 24 cases for L&T. But L&T, our business model is different. We do not believe in unnecessary litigation, and therefore won't see that we are going for 40 crores, 50 crores, 100 crores litigation. Most of our clients are government. So taking any panga from the client, you may be blacklisted also. Currently, we are operating in 62 countries, and most of our profit comes from outside India. Whole of the Middle East is with us, USA, and many parts of the world also. Now, I have a very interesting situation, and it's a live case I will share with you during coronavirus. Just listen carefully. We have been executing more than 3 dozen projects in India during coronavirus. You remember that 2020, in March, 28th March, this blockade was imposed in India. So, and after 1 week, there was an instruction to all the company that you will not remove the services of any of the contract labor, not regular employee. You will be paying medical benefit. You have to pay their lodging also. So on this count, L&T incurred, out of pocket about 1,600 crores. We believe in ESG, and L&T is, when there is an instruction, we believe in 100% compliance. There is no any sort of exception. So we incurred this extra expenditure. There were 8 interesting projects where it was a lump sum contract. Number 1, change in law limited to only if the tax variation is there. And lump sum contract, there cannot be any price variation clause. Now, situation is when we approach the Navratna, we were executing project for onshore, offshore, power project. We requested that, see, this project is meant for you. You are the principal employer. We are a contractor. Finally, that instruction is a change in law. There was no dispute on this. And you are also bound by that change in law situation. And you fall under Article 12, whereas L&T doesn't follow Article 12 of the Constitution. So you have more social responsibility. In the first instance, they suggested, sorry, we will see only the terms and conditions of the contract. What is the term? That it's change in law, fine. But we have clearly stipulated that we will only accept provided there is a change in tax rate. But here is you have paid to the contract labor, you have paid to the So that was the instruction of the government. We didn't want to go for litigation. That was our decision. So anybody can suggest, I mean, how to help L&T or the guy who have faces such a situation. So far, limitation is there. We can file, we can invoke arbitration, but we are not interested because I don't want to comment on current scenario of the arbitration. So I need expert views how to resolve the issue.
Settle it. That is Mr. Masih saying from experience.
I tell you, it has been settled. Couple of suggestions, because I'm in this profession also, only 25 years in construction. So, whether you are working as a general counsel or law firm counsel or senior advocate, one can understand the business only when he goes to see the business. If you are executing a coastal road or Mumbai Metro or any sort of worldwide, you need to go there as a not as general counsel, as an engineer and see what is happening there. Second thing, it's my suggestion, I'm not preaching you. Second thing is, youngster must spend 3-4 years in courtroom. That is most important, which I learned from my father, who was also judge, but he never allowed me. He said that first you go to the court. I read in my law book, sometimes the word doctrine of quantum merit. Based on quantum merit, read with 3 judgments of the Supreme Court, we send a letter to all Navratna. After a month time, at least I am happy to share with you, 4 Navratna accepted. They said, yes, what actually you have paid, you show me the documents. So actual payment was there. I mean, we have incurred and also. 4, we have requested many times. So since 4 have already agreed to pay and there was a circular from those company, the other 4 have also decided to pay, but yeah, very meagerly, not in a handsome amount. So what I intend to say is that construction contract or anything, it all depends on practice and procedure. It's not something rocket science. I would not say it's a rocket science. More you deal, more you learn, and which I have learned in 25 years. Thank you very much.
So Ravi Sabharwal.
Okay, I'll not take much of your time. I think we are at the end of the
He's the general counsel for JSW Group.
Okay, I'll come over there. So I'm an in-house counsel, so sorry for saying this because I don't like disputes. So I try to settle disputes, so lawyers may not like it, and I've been in practice. But as in construction contracts, it's a very heavily regulated industry. So whether you do a public or a private, for everything you have to go to government for approvals. So I know we have been talking about delays, but I think we have not spoken about the delays which goes into taking approvals, and more so when environment has become a bigger issue. For every small thing you construct, there's somebody who's filing a PIL or somebody stalling a project. Now, who's right or wrong? Maybe L&T does a lot of work for a JSW, but small things like there are delays because of COVID, this I think we can still manage, we can still settle. But there may be delays which, the construction industry would say is not to my account, or the contractor would say it would not be on my account, and we'll always be saying because we have to pay, we have to run business, we have to see that the construction is completed in time. So you may make watertight agreements. I have seen all over the world. If there are delays, and actually I think what has been said, facts and evidence which you prove is the most important thing. But anyways, I am an in-house counsel. I would always like to say, even if you have watertight contracts, you end in disputes, try to settle it. And I think, nowadays even the Indian courts are saying before you come for a commercial litigation, have a mediation done, and then you come for a commercial, for a dispute resolution. Thank you very much. I don't want to add more on this. Thank you very much.
Thank you, Ravi. Thank you very much. I think this is very helpful. And I think what is important is I really don't want to now stand in between dinner and drinks and giving you more gyan. I think we've had enough of today. But I think what, in a very positive note, what Ravi just said is that I think clearly we should have watertight agreements. Because we are working in Indian law with limitation of implied terms of contract and explicit terms of contract, damages clauses. So we have a lot of limitation. Getting anything out from anybody is very difficult, be it Government of India or be it L&T. It's all strong monopolistic players. And in that situation, I think what is more important is that we are almost getting to 8 o'clock. We should go out and have some fun. And I think I really invite you on behalf of Saraf and Partner and a Society of Construction that we just want to host you, and I hope you've had some good learning today. And I think what more important was to exchange our experience and basically bring a little bit of a boring and a fun element together. Thank you very much, and we look forward to seeing you outside in the garden. Thank you.
Hello.